You take the missing Malaysian airline, MH370. We all know about the plane. It disappeared. Now I'm asking you a question. When that plane disappeared, do you think the Malaysian government issued the death certificates immediately?
They're not presumed dead.
Thank you. Now, what does international law state if somebody's missing, presumed dead? There's a waiting time of up to 7 years before you can legally declare that person
So if
dead.
all these assets were owned by one of the two parties that have children and that person went missing, that's a clear issue.
You're in stalemate.
So that's where the power of attorney has. So the power of attorney has a clear benefit in these kind of circumstances.
Thank you.
Welcome. Today we have the pleasure of hosting Mr. Mohammad Marria on the show. He has a career of 30 years, been in the UAE for more than 20 years. Mohammad Marria is a seasoned expert in inheritance planning, specialized in wills, probates, and power of attorneys. He has built a reputation for guiding clients through the complexities of UAE inheritance laws, often tailored solutions that bridge the gap between conventional and Islamic Sharia law. This is a topic that's really deep to my heart because I feel like living in the UAE, there's a lot of different misconceptions of how probate or how what happens to the estate of an individual after they pass away. So I'm very happy to have you on so that we can talk about this deep topic. So tell me, let's start with your experience in the UAE and how much has UAE changed from a legal perspective of what happens to an individual's estate over time?
Well, I've been here since 2005. I must say in the beginning it was very challenging trying to educate expats, even legal experts, the courts regarding wills, probate, inheritance, registration of wills. So it was very challenging in the beginning. I was pleased to say that in November 2012, we registered the first will in the Dubai courts.
Oh, wow. And
I told you I didn't know what I was expecting when I took the client there. I even told the client, I don't know what's going to happen. They're doing it, and we're the first company to register the will. And the process was very, very simple. And I must say, over the years, things have gone much better. That not only the concept, the execution has been more simplified. So the courts are evolving when it comes to the concept of wills, registering and executing. And I must say it's probably one of the best systems in the world.
Oh, wow.
Because post-COVID, now you can register everything online. And when I talk to people in other countries, they're shocked that their own country doesn't have a system where you can have a video call and register your documents. So I would say the UAE in general is evolving. They're listening. They're trying to make things better. And I'm very impressed. And I always give my feedback, my opinions, trying to tell them how things can be better or trying to expedite the process. I know it's a subject people don't want to talk about. I know it's a subject people sort of brush under the carpet. But the fact is that we're living here and every country has their law. I'm not here to tell you which law is better because I can find faults in every law. But the country itself, the system is not telling you that a will cannot be registered. The system is there. You need to take advantage of it.
Makes sense. I think, it's important to highlight that we choose not to talk about this discussion of death. There's a big taboo about speaking about death and what happens in death within the family, but also there's a taboo of thinking about it as well.
Correct.
So this is a very new concept to many people. The majority of individuals in the UAE are expats, but even from dealing with UAE nationals, a lot of people don't know what happens. So how about we start with an individual who has assets abroad and in the UAE, and they pass away. What is the current legal process for what happens to this individual's assets internationally and locally? How do they get access to this? What do the dependents do in the absence of having a will or any circumstance of documenting where the assets are? What does the usual experience look like?
Number one, I tell everyone, make a list of what you own.
Make a list of what
you own.
whatever you own.
Whatever it is.
Yeah, because usually dependents wouldn't know, right? It's, okay,
let's
you know,
talk
God
about
forbid,
why.
my father has these assets. I don't know what assets he owns or
But
where.
the question is why people
Yeah.
don't share information. There's trust issues, ignorance.
Mm.
So, number one, making a list of assets to give a roadmap to your family, who to contact, where's the money, what's the account number. This is something you should be doing anyway. Now, if you put this information in the will, you'll be changing the will every 6 months.
Mm.
So making a list of what you own is the first thing you should be doing regardless.
Makes sense. So first,
Make a
putting in
list.
the list of the assets, because in this absence, the dependents and people get confused of what is there to
Exactly.
be reconciled.
Correct.
Okay. So let's assume now the individual has tried to recollect what is owned. Then what?
Make a will, draft a will, register it in the court. Now, let's talk about passing away with no will. Every country has a law. Now, in some jurisdictions, where the bank accounts are in joint names, by right of survivorship, the account will not be blocked.
Let's talk about right of survivorship more, because a lot of people don't know what right of survivorship means.
Right of survivorship means, my interpretation, people might think of it differently, but my interpretation is if you have a joint bank account between two persons, or you own a property between husband and wife, right of survivorship means that the share will automatically pass to the next person without a court order, without a will, without any probate. So let's say you have a bank account with HSBC. Now, if you have a joint account in the UAE, it's regulated by the UAE Central Bank, so they will block the account the moment the bank is informed.
Because there's no right of survivorship law in the UAE.
But the same HSBC sitting in UK, in Jersey, Singapore, same HSBC, branding, in those countries, they don't block it. So by right of survivorship, it will go automatically to the co-account holder.
So what's very important to establish is if I own any assets that are in joint, I need to identify, is there right of survivorship of these assets? And do I want there to be right of survivorship? And can I have the capacity to have them as right of survivorship? So if I die and I have a joint account with my wife, the question becomes, do I have right of survivorship on this? If I do, then if I die, then my wife gets ultimate ownership of 100% of it. If I don't...
Okay, if there's no right of survivorship, so if you take Canada, for a good example, South Africa, they freeze everything there. So when South African nationals talk to me, they know themselves that in South Africa, bank accounts are blocked, whether it's single or joint. So when it comes to these jurisdictions where accounts are blocked, you need a court order to unblock the account, which means you need to open up a legal air file or case in the local court. And then the court will send the order to the bank to transfer the money. But let's take an example. You own a property with your partner in the UK, and you don't want your share to go to your wife for whatever reason, then having the right of survivorship doesn't make sense because you don't want your share going to your partner. So you got to look at everything objectively, that where there is right of survivorship, are you happy it's going to that person, yes or no?
At the end of the day, it's a choice that one has to be cognizant of.
Exactly.
Right?
But coming to the UAE, and this is what people need to be aware of. And, when people tell me, or expats tell me, but this doesn't happen in my country. And I keep telling everyone, wait a minute, we're not talking about your country. We're talking about the UAE. You have bank accounts there. You pass away, the accounts will be blocked. There's nothing I can do. And the account will be blocked the moment the bank is informed.
And the bank should be informed.
I agree.
Yeah.
However, it's still case by case because at the end of the day, let's say you passed away outside the UAE, maybe the banks do not know. But if you are living, working, and you pass away here, they will find out. So the moment they are informed, they push the button, they block the bank account. There's nothing I can do. Now, to unblock the account, you need a court order. You can't expect, people usually say, what if my wife takes a marriage certificate? and go to the bank and say, give me the money. I said, it doesn't work. The bank needs a court order. You have to go to the court. Now, when you go to the court, they will ask you, is there a will? If the answer is yes, they will follow the wishes of what was written in the will in the first place. If there's no will, the law of the land will apply. Now, we can sit down and talk about who gets what. Point is, if you want the control, register a will. It's simple as that.
So to summarize my understanding thus far, and I think it's very important to highlight the right of survivorship, because let's imagine I buy a property with a cousin of mine as an investment. And then after buying this property with a cousin, I pass away, and I actually intentionally wanted my family to be the inheritors of my share with right of survivorship. Potentially now I've forsaken the entire asset to the right of survivorship to my cousin. So that's one thing. And then if there is no right of survivorship in a country like the UAE, Canada, or South Africa, or others, then a joint account is simply seen as a 50-50. So it's seen as
Correct.
You own 50%, I own 50%. 50% gets...
during your lifetime, you both own the account 100%.
Correct.
However, post-death, for legal purposes, you own 50% and the co-account holder owns 50%. So let's say you have 100 dirham sitting in a joint account in the UAE. Then for legal purposes, you own 50 dirham, your partner owns 50 dirham. Now, that same account was in the UK. The whole 100 goes to the co-account holder, the survivor. That's it.
So if, in a very relevant example in the UAE is, if I own a property in the UAE, essentially, if I own it jointly, in the title deed itself, it says how much shares I own, how much the joint party owns. So there is that percentage ownership. Now, when we say things get blocked, is it entire joint account gets blocked, or is it the asset gets blocked, the 50% of the surviving individual gets released, and then only the share of the deceased gets blocked? How does that usually work?
First of all, the bank account is blocked, meaning no one can take money out. That's it. Property is blocked. It doesn't mean you can't live in the property or someone's going to, sorry to say, tell you to leave. No, it just means you cannot transfer or sell until you get the relevant paperwork in order. So if there's a joint property, you own 50%, the property owner owns 50%. So if you pass away, the co-account holder will keep the 50%. Now we are looking at your 50%. Where does that go? And same thing, vice versa as well.
Okay. So I'm in the UAE. I have assets in the UAE and I have assets abroad, and I pass away. Essentially what we're saying is I need, or my beneficiaries or whoever wants to distribute my estate has to go and get a court order from the local
courts,
to decide where my assets go to.
Correct.
What about for me, who is an expat living in the UAE? How about the assets I would have in, let's say, Canada or Lebanon? How does that happen?
Every country has their law. So again, you need to look at the law of the country. That's why I gave an example, like Canada freezes bank accounts, UK doesn't freeze accounts. You go to Germany, France, Italy, Spain, they freeze joint accounts. But some countries don't. So you need to look where the money is. But respectfully, I keep telling people, don't keep money unnecessarily in too many jurisdictions. It's not what the will states, who gets what. Who's going to do the work when you're not there tomorrow? You want your family going from A to B, B to C, employing legal, going to different countries. Don't keep money in too many countries. Just try and keep it in a handful. Not even a handful, I would say usually in the UAE, in your home country.
Mm.
I had a case, somebody had a bank account in Singapore. Now, foolishly, he had the account only in a single name, not joint. Because it was single, it got blocked. Now, he had about 100,000 dirhams in a single bank account in Singapore that was blocked. And it costed the family more than 40,000 dirhams in legal fees, going backwards and forwards, court fees, just to block the 100. And when I asked the wife, when you don't live in Singapore, you have no connection there, then why you've got all his money sitting there? They said, oh, the bankers said that you should keep some money offshore. I said, well, your banker should have told you to keep the account in joint names because they have right of survivorship.
So what happens a lot in the UAE is, if my home country is Canada
Mm-hmm.
and I live in the UAE,
Mhm.
what happens a lot of times is I don't want to have a high store of wealth in Canada for legal tax avoidance purposes. It's complex. It's not made for non-residents of Canada to have assets there. So I end up having an offshore account, whether it's in the US, whether it's in Jersey, whether it's in Singapore. And then I have my assets in the UAE, I have my assets in the offshore jurisdiction, whichever one I choose,
And Canada.
and Canada if I have assets in my home country as well. And therefore, what we're saying is each jurisdiction will have its own courts that would have to release the assets. And that's
Right.
in the absence, and in the absence of a will, that complicates things further because the relevant court in that offshore center essentially would find it hard to make a judgment on that, or what happens in that
Like
kind
I
of
said,
circumstance.
if it's a joint bank account, by right of survivorship, the money goes to the co-account holder.
But what if it's a sole account, right?
Right.
We're talking
You
about joint, but not a lot of accounts are not joint.
You need a court order then. How will the bank, who is the bank going to release the money to? How do we know who your legal heirs are? You might have two wives. You maybe don't want the money going to your wife, you want it going to your sister. I don't know. Bank doesn't know. Court doesn't know. This is why they freeze everything. And you got to go through a process. Now, we say the dead cannot speak. Agreed?
Yeah.
I disagree. The will is speaking.
Mm.
The will is speaking on behalf of the deceased. So why are you not drafting your will? It comes back to what you said earlier. It's a taboo. People don't want to talk about it. Well, I say you have to talk about it. You know, it's not rocket science. Everyone's going to leave this world. It's how you want your family to deal with your estate after you're passing away. That's the will. This is why I get busy when people pass away, because you don't need to do the talking. The problem's already there now.
Yeah, and it's also, it gets beyond that complicated. I think on both sides, we have a lot of female clients, for example, and they have their accounts in sole accounts.
Yeah.
They're married, they have children, and essentially, when the children are minors, how does one make sure that the assets get taken care of, the children get taken care of, the assets are spread the way that the individual wants?
Guardianship, that's part of the will. Now, you're talking about female professionals. You ask the common female professional, if you pass away, do you want your money going to your husband or your children? 99% will say the children. Why? I tell you why. Because they don't trust their husband. They're thinking if they pass away, husband gets the money, he'll go and get married again. Who's going to lose? It's the children.
Yeah, I feel like anyone who has children under a specific age, at the end of the day, the most thing they worry about is to make sure that their wealth goes towards giving their children the right life up to a specific point. But let's then...
That's the voice from the grave I was trying to refer to.
And that's the voice that you're mentioning is in a will.
It's in the will.
So let's talk about a will. So I think there's a few things to talk about. There's the role of an executor, which I know, but I wanted to deep dive into that. You talked about guardianship, and then it's the will in the UAE in terms of my foreign assets versus my local assets. So let's first start about the role of an executor. Based on my understanding, when I'm drafting a will, what I need to nominate first is I need to nominate an executor. Can you talk more about what is the role of an executor in a will?
Look at the executor as a PRO, doing the legwork, maybe to speak to the bank to clear the loan, to clear your credit card, settle your mortgage, deal with the insurance company, transfer the assets, settling the accounts, making a statement of account for the beneficiaries. This is how the money was utilized.
So the executor is someone that the deceased would have trusted to say, hey, if something happens to me, I want to make sure that you take on the responsibility of doing the legwork.
Usually the spouse. However, in my experience, the spouse wouldn't know what to do. So in the will, we always add a clause that the spouse or whoever the executor is, they can appoint a third party to do with the execution.
Okay, because it's something that maybe the person who's grieving or doesn't have the expertise to do and to go around and get that done. So the executor can be a trusted family member, it could be a spouse, or it could be a third party, which is supposed to do the legwork of finding out, okay, what are the list of accounts, getting the letter of the death certificate, going to and doing all that legwork, and now they have the legal authority to do so, and that person is nominated within the will.
Correct.
Okay.
So the executor is the person doing all the legwork. It can be the spouse, it can be a professional, it could be a family friend. It's just somebody who will do the work. I'll give you a real case example. The wife passed away, and the husband, there was a will, and the husband contacted me and said to me, can you do the work in the court? And I said, look, you've got the will, do the work yourself. He said, look, I have just lost my wife. I've just taken 1 month off work. Do you really expect me to go to the courts and deal with all the paperwork?
It's the last thing you want to do.
Last thing on my mind. I'm at home with my children, grieving for the loss of a wonderful person. So he gave us the authority. You do the work. The question I asked him, or the information I wanted, what did your wife own? So he furnished me with a list of assets. So when I'm going to the court, I'll tell the court which bank account the money's in. Here's a copy of the title deed. Here's a copy of the mulkir for the car. So I had that information. But in reality, people don't have those documents.
So let's start with then the local assets. So I know there's a lot of confusion of Muslims and non-Muslims. For local assets, can either write a will covering local assets, or how does that work, first of all?
Look, when I'm talking to a person, I need to understand which jurisdiction he's holding the money in.
So let's start with the UAE. Let's assume
UAE,
for now,
no problem. Regardless of your religion, anyone can register a will.
Okay.
So the courts are now even allowing Muslims to register a will as per their wishes, having full control of all their money, not subjected to the 1/3 as per Islamic law. That is what you have a control. Court is allowing the Muslim to register the will in a civil court, which means you have full discretion of your money, who's going to inherit on your behalf.
So as per the current laws at the moment, because it's fast changing, regardless of religion in the UAE, someone can write a will that rules over their assets within the land. And now for foreign assets, this is something that that introduced me to you, is my concern was, okay, how do we make sure that we have a seamless process for someone that has foreign assets? So what benefit is there of writing a will in the UAE over foreign assets, if any?
It's country by country specific. So now we got to look at the classification of assets. There's a difference between movable and immovable. So movable is like your money investments, your offshore bank accounts. Liquid.
Yeah.
You have an online trading platform. I can cover that from the UAE. But if you own a property in France, or you got a holiday home in Florida, I would recommend it's better you make a will there separately.
And that's an immovable asset.
Correct.
Yeah. So when we did it to speak to, we work with Interactive Brokers, and we spoke to Interactive Brokers, and they gave us the indication that what matters is the country of residency.
Correct.
And having an order of probate, I believe it is.
Grant of probate.
A grant of probate from the country of residency could apply in the offshore center, because the client is neither a resident or a citizen of that country.
Correct.
So walk me through what a grant of probate is then.
Right. When a person passes, when you register a will, the will is obviously registered in the court. Post-death, the court will issue a document called a grant of probate, which is very similar to the will, but post-death. So in the grant of probate, they will say this person has passed away, such and such date. He had a will. The executor of the will is XYZ, and the beneficiaries of the will is ABC. That single document, aka the grant of probate, can be applied to unblock your offshore investments. Some countries, that grant of probate can be applied to unblock your immovable property. But remember one thing, that document is not there to supersede, override any tax laws.
Clear.
So remember this, that if you're a US national, whatever the inheritance tax is in the US, this grant of probate is not there to cancel the tax. So we say death and taxes are unavoidable.
And that's the difference very much between movable assets and movable assets. Immovable assets are ones that are very much in a specific location, can't be moved. And movable assets, for example, investments, you could have investments that are in a specific jurisdiction.
Immovable is your property. Movable is your liquid funds.
Yeah.
So I'm saying that with a UAE grant of probate, I can unblock movable, all your liquid funds in many countries in the world. Yes, they might, like Singapore, they need an affidavit from the Singaporean consulate to be attested in addition to the grant of probate, but another country will accept it in its current form. Maybe you have to take it to another embassy. You might need other government stamps. But these stamping can only be done post-death.
Okay.
So the grant of probate, in a nutshell, it's the will that the court issue post-death detailing what was written in the will.
Okay. So step one we talked about is list the assets, right? The
Correct.
easiest thing to do, you don't need anyone to do that. List the assets and have them, at least for information for the executor,
Share
for your
it.
beneficiary, share it, or
And
have a
update-
mechanism of it being shared.
Update it as well.
Keep it updated. It's easy to update. And then the next thing is the death does have a voice through a will. And in the will, we spoke about the role of the executor. What other things are there to look out for when drafting a will? What's important?
Guardianship, if there's children, which is split into two parts. You have the interim guardian, somebody living here, who will get to the scene immediately. Now, let's speak about guardianship. This usually applies if, in case, God forbid, both the parents pass away. So I remembered back in 2008, the first case that came to me was when the parents passed away in a car accident. The children were at school.
Oh.
And the school didn't know what to do, who to contact. It's 3 o'clock, 4 o'clock, 5 o'clock. Their school they don't know what to do. So who do they call? The police. And the police came to take the children into custody. They obviously contacted the embassy here to try and track down the grandparents or the extended family in the home country. By the time all the documents got sorted out and the grandparents came, it took nearly 3 months.
It's terrible.
I tell people, don't ask me, where were the children in that 3-month period? This is why when drafting a will and there's minor children, appointing interim guardians is very, very important.
So you're saying that, so I have 2 young children, and what we're saying here is that the will isn't only on my assets, but we're talking about, so it's assets and guardianship. And you're saying something happens to me and my wife, and I want my parents to be able to take custody of the kids. There might be a prolonged process in which they don't.
I'm saying having the right paperwork at the right time will save any delays. That's why, because don't forget, people like us living here, our parents are not here, they're in their home country. How long will it take for them to come here? We don't know. I mean, you take COVID, it's such a good example. Love of money, people couldn't travel. So you imagine there's a case, parents died, and your family can't travel. Then interim guardians are people living here who will get to the scene. It could be your neighbor, it could be a friend, a work colleague, someone you know from the school. This is an interim guardian. They will step in and give the children food, clothing, and shelter. Then they need to contact the permanent guardians, your parents, your siblings, who will come here and take the children. Now, maybe they need to apply for visas. I don't know.
Who's the interim guardian taking control of the situation until then?
Thank you. So that is the guardianship, interim and permanent. The executor's dealing with the financials, making sure the money's transferred, your debts and liabilities are settled, document clearance. It's not a simple task. It's a very tedious process. I mean, repatriation. Do you want to be buried, cremated? No one even talks about this.
Yeah.
I mean,
I don't talk about it in my family.
I had a case where the son died, who was quite ill, and the parents were talking, do we cremate him? Do we bury him? Does he want his organs to be Does he want to give his organs away? No one talks about
Is
this.
that in the will or a letter of wishes?
That would recommend a letter of wishes.
Okay.
Why? Because you don't want to keep changing the will for these changes. So letter of wishes are very informal requests. So let's say you want to do charity. Let's say you have, I don't know, what do you call it? A diver's watch. You want to give this to your brother. Letter of wishes. You're sponsoring a child. You want this to continue post your demise? Letter of wishes.
Is the letter of wishes attached to the will, or is that with my letter or my assets? So let's first of all differentiate with the will and the letter of wishes. So the will is something that I register in the court
with a court stamp.
And it's not that it's hard to change, but it's not easy to keep on changing the will.
You see, for me, it's not an issue changing the will. It's just you need to start the process again, pay the court fees again, and so forth. This is why I tell people that when it comes to informal requests, so let's take an example. You want to be buried. Then after 6 months, you say, I want to be cremated. You have to change your will.
Mm.
So it's better you put it in the letter of wishes.
Yeah, and there's a cost that comes with it.
Exactly.
There's
I'm
a
just
legal
trying
process.
to avoid all of that.
Yeah. So essentially, you have the letter of wishes, which is something that is not within the court, but it's almost like an attachment, like an appendix to the will. So that the executor and the beneficiaries and everyone know, oh, this is also the voice of the dead in terms of what does the deceased person want in the absence of remembering or even had that discussion. So you have the list of assets, you have the will, and you have the letter of wishes. And what we've covered so far in the will is you have the executor and you have the guardianship, the interim guardian
and the permanent
guardian.
So permanent would be say your parents who will come here. But I recommend after your parents have your siblings.
Yeah.
In case your parents.
So you don't have to change it.
Thank you.
Yeah.
So whoever the permanent guardian is, they will come, take the children, go back to the home country. The interim guardian is just babysitting them, giving them enough time for them to come and take the children.
Makes sense.
Executors dealing with the formalities.
Makes sense.
Even the, like I said, funeral arrangements, even when it comes to document attestation, clearance, all of this, that is the executor's responsibility. Now, the executor can do the work themselves. Let's say you appoint your spouse. Your spouse can deal with the execution, or spouse might say, wait a minute, I can't deal with this, and your spouse appoints someone else to do the work. That is possible. But for me, having, I can't think of another word, the death folder is what everyone should be doing today.
And what's in the death folder?
The death folder is basically all your documents. So I'm not talking about the will or the list of assets. I'm talking about your marriage certificate, children's birth certificates, your title deeds, any life insurance documents.
I have that folder.
You should have this folder.
Yeah.
And this folder is what you're giving to the executor. So that tomorrow when the executor's dealing with any paperwork or any transfer of assets, you have all the right documents. So I'm going to ask you a question. If you want to leave your money to your children, say husband and wife both pass away, say a woman, professional woman, wants to leave the money to her children. She's no more tomorrow. Who is the court going to send the money to?
So how does that work in terms of the role of the guardians as a beneficiary taking care of the kids? How does that work?
Guardians raising the children like a parent.
Yeah.
Executor is the person dealing with the financials.
So let's imagine.
So if the money is in the bank and you want to transfer it to the children, the executor will give all the paperwork to the court for the transfer. But my question is, where the court is going to send the money? Who's
to the beneficiaries?
The children are minor. Have they got a bank account?
No, definitely not. They can't.
So
they're not going to have an investment account.
Why are you not opening the bank accounts today? Do you know banks are allowing children to open bank accounts?
Is this a new change? Because I remember that before I couldn't open a bank account in the name of a child.
You can, but it will be a savings account, not a current account. And you, as the father, will be the caretaker of the account, but the account is in your child's name.
And what happens in my absence?
Obviously, the executor is dealing with the account, but the account is in your child's name.
Okay. So, and then...
Or let's say the children going back to the home country. Mother, father, no more. Children going back to the home country. You want the money to go back to your home country. Have you opened up a bank account for your child in your home country?
Mm-hmm.
You haven't done that. That's what you need, that death folder. You need to open up bank accounts for everyone.
So it's about having a plan.
Exactly.
It's about having a plan.
A roadmap, I would say, for
And
everything.
if you put enough time into it, you can finish that plan, have it set, and then choose not to think about it again.
Correct.
Okay. Very interesting. And so there is the element of guardianship, and there's then the element of beneficiaries. So beneficiaries also, would it be beneficial to have what the beneficiary account details are, or is that not really relevant?
No, it will change tomorrow.
Mm.
You're banking with Bank A. Tomorrow you'll be Bank B. I'm not going to keep changing the world because you've changed an account. Update the list of assets.
Mm.
But even beneficiaries, you need to look at it objectively. So you might say, I'm giving everything to my wife. Wife saying, wait a minute, I'm giving everything to the children. So your beneficiary is different to your wife's beneficiary. Now take an example. God forbid, the whole family goes in a freak accident. You got to have another level. Who's going to get the money?
Mm.
Court will transfer the money. But the executor needs to have a copy of the will so he knows who the money should be going to. People don't think about this.
Yeah, I don't think about this.
No one thinks that far ahead. So when it comes to the will, I'm looking at every eventuality. If you're not there, what happens? If your wife's not there, what happens? If both of you are not there, what happens? If the children are no more, what happens? So we have to put levels. So like you have the executor, his job to do the execution. Guardianship is split into two parts. You have the interim, who will get to the scene. Like I said, could be a neighbor, friend, work colleague, someone at the school. Permanent is your parents and your siblings. And who are the beneficiaries? This makes up the will. The letter of wishes deals with informal requests, burial, cremation, organ donation, any charity work. Maybe you want to give someone money, or maybe you have jewelry, family heirlooms. That goes in the letter of wishes. Put all those documents together with the marriage certificate, the birth certificates, your title deeds, and insurance documents, your online training platform document. Put that in the folder. I call that the death folder. That folder is what you need to be preparing and sharing.
So a lot of times what we do is we have clients who have very specific investment objectives, right? We work as financial advisors on goals, whether that's a goal of preserving wealth and growing it for their retirement, or whether it is for the children's university education, or whether this individual has already generated enough wealth and they want that wealth to distribute them an income to give them a passive monthly income. And a lot of times we have couples that are our clients and joint, but also we have sometimes a couple, but one of the two is taking the primary lead in terms of how the investments are being managed and what's the objectives, etc. So how does one make sure the fact that, if God forbid they pass away, how to make sure that a lot of the information of how the assets are to be managed or to be run goes towards the next of kin? What I've seen very much recently is now with DIFC foundations or ADGM foundations or trusts, there's these different structures that allow for continuity of the asset management a particular way and continuity in regards to the legacy in terms of the estate of the individual. So how does that usually work in practice?
It's always case by case, because don't forget, if you have a foundation, the foundation is only covering the assets that you transferred in the foundation in the first place. Now, one thing a foundation cannot do is manage your children. So that's where you have the wills. In some cases, you need the will and the foundation. So the foundation, it's basically an entity that has its own succession plan that you don't need to go to the court to apply for the order. There's no probate. It's all done internally. In a nutshell, that's what a foundation is. So let's say you have a bank account in your personal name, or you have a car, which everyone does. Now, to transfer the car from A to B, or the bank account from A to B, you need a court order. So you have to have a will to cover that. But if you put the car and the bank account in the foundation, there's no court order.
Mm.
It just goes like right of survivorship immediately.
So we're starting with defining what the foundation is. So we're saying a foundation is a legal entity of its own right that doesn't die, or at least unless it's being killed, it continues.
But it will only work on the assets that you transferred.
And the assets have to be owned directly by the foundation. So I have to gift my assets to a foundation or to a trust for it to be an ongoing concern. So it to remain alive regardless of what happens to me.
Correct.
And then I can nominate rules of who's managing the foundation, who's the beneficiaries of the foundation.
And who gets the money, and you can make it more complicated that your children will get some money when they're 21, some when they're 25, they get married, they can have something, they want to go on holiday, you can add this. I mean, it's the choice is endless, but it's not everyone's cup of tea. Why? Because if you have a property and there's a mortgage, you can't transfer the property into the foundation because the bank is not going to give the NOC. So it's good for unencumbered properties, liquid assets. It's mainly for the sort of the people having multiple assets. For the common person, no.
And it's expensive.
Nothing is cheap.
Yeah,
there is an objective, but it's not everyone's cup of tea.
So what we're saying is the foundation or a trust has specific benefits, and the benefits are how it can be customized and how it can supersede courts in general just because the assets are already gifted to it. But what you're also saying is even should someone do a foundation, based on this discussion, it's very important to also write a will because you have the assets that are not in the foundation.
You have children.
And you said the guardianship, the executor,
you can't put that in the foundation. Foundation is more for your financial assets. So you have a company's trading. You don't want the company bank accounts to be affected. Foundation makes sense. But if you're telling me you're having personal bank accounts, you're having cars, you got children, you can't put that into the foundation. You need to have a will for that. That's what I'm saying. You might need both.
Yeah, and you see that a lot, especially when it comes to companies. People own companies. The company, at the end of the day, needs sometimes shareholders to take specific decisions. In the absence of the shareholder being alive, having it in a legal structure, such as foundation, removes a lot of the interim issues that would be faced by the estate in managing that company, or it gives that company a longer lifespan, essentially. But what you're saying is, yeah, that's only for those assets that would be gifted to the foundation.
Correct. Respectfully, if you set up the foundation and you don't do the transfer, then there's no point in having the foundation. I know people who have done that, and they are renewing. The funny part is they're renewing the certificate of incorporation every year, spending thousands of dollars on setting it up and running it, but they haven't done the transfer. And I think
why is that? Is it they don't trust it as a structure? Is it maybe a difficulty in moving my assets to out of my name?
Laziness. It's just ignorance. That's all. I mean, they're not saying they won't do it. Yeah, I'll do it tomorrow.
Procrastination.
Tomorrow. That's it.
Yeah, we procrastinate a lot of things to do with our personal life.
Human nature. It's human nature. I'm sorry. This is why I told you I get busy when people pass away, because now it's like the problem has occurred. Now we have to deal with the red tape.
Can't imagine how challenging COVID was for you, from a career perspective.
It was, something that took everyone by surprise. Must say, the court shut down. People didn't know what was going on. Even people who couldn't travel, the visas were being cancelled. So it was very, very challenging because I won't say to the UAE, I think no country was prepared. No one knew what to do. And people, sorry to say, in terms of whatever solutions they thought would work, it didn't work. But one thing I like about the UAE is that when it came to the document registration, wills, power of attorneys, they have a video call system, which I think that means you're sitting in Canada. You can't travel, but you can now register a power of attorney. Now, you try and do that in Canada, you can't do it.
Yeah, we're moving forward fast.
Sorry?
The UAE is moving forward fast.
Very fast. In fact, if you look at the GCC, the UAE is the only country in the Gulf that has a system to register wills. So you go to Qatar, they don't have it. You go to Oman, they don't have a will registry system yet. I'm hoping they'll have one. I'm trying to see if I can help them put a system in place. The UAE is the only country that has not one, not two, not three, but 4 different court systems to register a will.
That's fantastic. What are the 4 court systems?
It's the Dubai court, the DIFC court, the ADJD, and the ADGM, the Abu Dhabi Global Market.
And ADJD is like onshore Abu Dhabi, is it?
Correct, spot on.
Okay.
I'm more of an ADJD fan because they're allowing both Muslims and non-Muslims to register the will, and they're the cheapest in the UAE.
Interesting. And you have plenty of experience in this domain. So what are the blind spots that we don't think about that we haven't discussed, if any?
Life assurance.
And so let's talk a bit more about life insurance. So I feel like
I don't sell it, by the way.
Yeah, I know
I
that.
think I can do a much better job than the people who are selling life insurance.
Unfortunately, it's missold a lot in the region.
It is missold, and the problems here, I'm sorry to say this, but many people are underinsured.
I feel like most are underinsured, and then the individuals who choose to then get life insurance are sold it the wrong ways and the wrong instruments.
Correct.
Because there's an incentive scheme that comes to financial advisors who sell it. So it's not necessarily done the right way. So first, let's start with defining life insurance. So life insurance is, I have an insurance policy, I pay a premium, so I pay a monthly amount or whatever it may be. And then if I pass away, I have beneficiaries who get a lump sum or a specific amount of money. So can you give us more? So there's an obvious benefit for life insurance for individuals who don't have enough, right? So let's imagine I have $100,000, but I have 3 young children who go to school. Most likely that $100,000 will not see them out for their entire education in their university. So here's a clear need for life insurance. But a lot of people who have larger amounts of wealth sometimes think they don't need life insurance. So can we talk about life insurance from both aspects?
Okay, so life insurance. Number 1, always complete the beneficiary form. So you go to company A.
That should be a given, right?
Like,
is there anyone who would take a life insurance and not write the beneficiary form?
I can't name the companies, but yes, there are companies who will sell you the policy, but they don't complete the beneficiary form.
What's the point of having a life insurance if I don't have a beneficiary?
That's my argument to the people selling the life insurance in the first place.
Yeah.
Number 2, make sure the amount is right. So, for example, you have a mortgage. You owe the bank $1 million dirhams. So what the bank will do is insure you for 500 and your wife for 500.
It should be $1 million each.
Exactly.
Yeah, because I want to make sure that if she passes away or if I pass away, the remaining individual doesn't have to take on the burden of the kids, the expenses, everything, and the mortgage.
But don't forget, if your wife is a homemaker, she's not having an income, even though half the mortgage is cleared, we cannot get the NOC from the bank to transfer the property to the wife because the bank won't give the NOC. There's a 500,000 dirham outstanding.
Oh, so you're saying that the loan won't be passed over and then the bank might request or require it to be paid off?
The bank will tell the wife, sell the property and pay us back.
Oh, wow. So what we're saying here is the importance of life insurance when it comes to debt is the first benefit is cover off any debt so that it's not paid from the asset itself.
Correct.
So that's the clear one. And then?
Let's say you have a car loan. For your reference, and I can speak on behalf of every bank in the UAE, life insurance is not mandatory. So you take out 200,000 dirham for a car loan, the bank is not taking out life insurance on you because they feel that if you pass away, they'll take the car back from the family, which is wrong. The bank should have life insurance. Now, the bank's argument is that, if we tell the customer to take the life insurance, the customer might not take the car loan. So I'm not blaming the bank. The customers need to be educated. I think everyone needs to be educated because I'm not saying it's always the bank that is giving half the life insurance. Maybe the customer's saying, look, I just want half. My wife's got half. Combined is the 100%.
So the first recommendation is for any debt I have, I should have life insurance to cover that debt. So that's
Let's take
number
a step
one.
back. Do we know who's going to die first, the husband or the wife?
No.
So the husband goes, total his debts is 100%. Take the life insurance for 100%. If the wife goes, total everything is 100% or 100 shares. Take out the life insurance for 100 shares. Now they both go. You want the money to pass to the children. Have you completed the beneficiary form? The will is there. But you need to go through the process. You need to get the grant of probate. It's not going to happen overnight. It's going to take time.
So definitely fill out the beneficiary form, because in the absence of the bank, so first priority should go pay off the debt. Second priority should be whatever remains to be paid out to these beneficiaries in accordance.
If you don't mind me saying, everything is connected. When I said in the beginning, make a list of assets, it doesn't mean you sit down and just make the list and forget the will. I think everything has got to be done parallel to one another. So making the will is one part. Having the list of assets, second part. Checking with the insurance company if there's a beneficiary form is the third part. Having your marriage certificate attested or your children's bank accounts opened, that's all is all connected. I can't say this is more important than that because I don't know who's going first. Let's take an example. Somebody's brain dead, incapacitated or in a coma. Can a will work?
I'm not sure.
Think about it. You're on a life support machine.
I would say no. I'm not dead.
So what do you need?
I probably need an insurance that covers me in the case of disability, permanent and
But
total
who's going to
disability.
manage your affairs?
Do I need a guardian?
You need a power of attorney.
I need a power of attorney. Okay.
Now, this is something no one thinks about.
Can the power of attorney only be in power if I were to be in such a circumstance?
Unfortunately, power of attorneys are not conditional. It's unconditional. You can restrict a power of attorney. In other words, you give a power of attorney to your partner or your business partner, they only can manage the shares of the company. That's it. But they cannot sell it. They cannot transfer it. So even power of attorney is a completely different topic altogether, but I recommend it. The best example I give to everyone, you take the missing Malaysian airline, MH370. We all know about the plane. It disappeared.
This is the Malaysian airline that
The
disappeared.
Malaysian airline, it disappeared. Now I'm asking you a question. When that plane disappeared, do you think the Malaysian government issued the death certificates immediately?
Oh, wow.
Did
Yeah,
they?
we never
they
think
can't.
about that.
No,
Yeah.
but-
They're not presumed dead.
Thank you.
Wow.
Now, what does international law state if somebody's missing, presumed dead? There's a waiting time of up to 7 years before you can legally
7 years.
before you can legally declare that person
So if
dead.
all these assets were owned by one of the two parties that have children and that person went missing, that's a clear issue.
You're in stalemate.
So that's where the power of attorney happens.
Thank you.
So the power of attorney has a clear benefit in these kind of circumstances.
Thank you.
So in the interest of time, because I know we're short on time, to summarize, power of attorney is within the lifetime. Life insurance is for immediate relief for things like debt, and should there be any. I know through my history as a financial advisor that life insurance can also have a benefit for by the time the court releases the assets, there's a time of what about funeral arrangements and what about other things? I'm assuming that's something that you would look at as well.
Look, unfortunately, there's no prepaid funeral plans within the UAE.
Is there in other countries?
In other countries.
Okay.
So you need to take this matter up, separately. But one thing I will say is always important to have emergency bank accounts, have life insurance, beneficiary forms. That's why I'm saying you need to have that death folder. And there is a checklist I give to every one of my clients. Put the folder in order. So whoever picks it up, they have a roadmap on everything.
Do you mind if we put that in the show notes?
Please.
The what you recommend in the
Yes,
death
we
folder.
can do that.
Yeah, to that point, I get very surprised. So we do, for our clients, we do financial planning. And what we do in financial planning is we map out the client's assets. Now, in some circumstance, you see clients who, they come to us and they say, oh, I already have this. And they send it to us. And I think you would know this answer. But how much people don't have that list? How much percent? It's like 90% of people don't have that
I would
list.
say very lucky, even 5% have it.
Yeah.
The reason is because people think they have it, but it's not all up to date. So for me, and please don't take it the wrong way, I'm not here to catch people out. I think one thing good when I'm talking to people, for me to talk or paint a picture post-death is easier than someone in your position when you talk about financial services. That's why I told you I don't sell life assurance. But when I'm talking to people, they understand it more because I've already painted that picture. You'll know more. How's your family going to deal with the post-death matters? Do you know how much it costs to repatriate a body from the UAE?
No.
You're looking minimum 15 to 20,000 dirhams, plus the tickets. I'm talking about cargo. Yeah.
Oh, wow.
So when your bank accounts are blocked, credit cards are blocked, where are you going to find 15,000 dirham? Who's going to pay for the utility bills? Who's putting the food on the table?
Yeah, it's something us financial advisors should do a better job in talking to clients about this type of circumstance and working together as an industry. And
paint a better picture for them to understand. Get the beneficiary forms filled in. I don't want to pick on any of the brokers or the insurance companies, but I have even dealt with cases where the bank claimed there was life insurance to cover the mortgage and there wasn't any. The bank claimed there was life assurance.
Maybe it was stopped being paid, something happened.
We don't know. But then what do we do? That's why it's down to the family to have the right paperwork. Don't cut corners. So if you are working in, I don't know, you're a pilot in Emirates Airline and you have life assurance, death in service benefits of 3 times your annual salary, don't use that as life assurance to clear your mortgage. Some people were doing it for them to save money. But I had a case where the person died and he was in between jobs. So there was no life insurance payout. The bank wants the money. The wife had to sell the property.
And no one will regret not dying, right? You live a long life. You won't regret the payments that you made. As long as you have the right financial plan to see you through, you're not going to regret not paying the premium to make sure that you're covered.
This is up to you. I mean, I'm sure when you speak into your clients, you give all the information. But there's some things you can't be controlling all the time.
Yeah. Unfortunately, we don't give out life insurance as well.
Okay.
But something that I also recommend, even in the absence of not offering it, it's something that's important. So to summarize, because that was great, power of attorney, life insurance, death folder that incorporates everything, letter of wishes, a will, and a list of assets.
Correct. And all your fully attested documents, your marriage certificate, children's birth certificates, emergency bank accounts. So I always say A, B, C, D. Joint account bank A. Husband has a single bank account in bank B. Wife has a single account bank C. Children's bank D. E's offshore. So if the husband passed away, the joint account is blocked. His single account's blocked. But the children's account and the offshore account is not blocked. If the wife passed away, the joint account is blocked, her account's blocked, but your account, the offshore account, children's account, it's not blocked. A, B, C, D, E. Now, banks won't give you this information.
Indeed.
They always want you to keep all A, B, C, D, E in the same bank. I said, no, you segregate them.
Clear.
Keep them separate.
We can go on for hours.
We can.
Thank you for your time.
I just started.
And thank you for the insights. It was a pleasure having this call, having this meeting, and we'll put the extra notes in the notes. Thank you so much.
Thank you very much for your time.